Today, my topic is violence against women. Violence against women is as old as the human civilization. It is a manifestation of the historically unequal power relations between men and women, which have led to domination over and discrimination against women and to the prevention of women's full advancement. Violence against women throughout the life cycle derives essentially from cultural patterns, in particular the harmful effects of certain traditional or customary practices and all acts of extremism linked to race, sex, language, or religion that perpetuate the lower status of accorded to women in the family, the workplace, the community, and the society. It is an obstacle to the achievement of the objectives of equality, development, and peace. It violates and impairs or nullifies the enjoyment by the women of their human rights and fundamental freedoms. In the societies, to a greater or lesser degree, women and girls are subjected to physical, sexual, and psychological abuse and cuts across the lines of income, class, and culture. The low social and economic status of women can be both a cause and a consequence of violence against women. Definition: violence against women means any act or conduct which has potential to injure or hurt women physically, mentally, emotionally, socially, and also spiritually. Article 2 of the Convention on Elimination of Discrimination Against Women, 1967, defines violence against women. The article states that violence against women shall be understood to encompass number B, physical, sexual, and psychological violence occurring within the general community, including rape, sexual abuse, sexual harassment, and intimidation at work, in educational institutions and elsewhere, trafficking in women, and forced prostitution. Number C, physical, sexual, and psychological violence perpetrated or condoned by the state wherever it occurs. Other acts of violence against women include violation of the human rights of women in situation of armed conflict, in particular murder, systematic rape, sexual slavery, and forced pregnancy. Acts of violence against women also include forced sterilization and forced abortion and coercive forced use of contraceptives, female infanticide, and prenatal sex selection. Historical background for development of laws relating to violence against women. Ever since the inception of the United Nations till date, the UN has worked to secure women's legal equality. A comprehensive program by means of various conventions have been chalked out to uplift and develop the status of women in education, politics, social status, etc. Hence, the formation of the Commission on the Status of Women in 1946 and the adoption of Universal Declaration of Human Rights in 1948. A massive research had been undertaken by the UN, and it has been found that in many parts of the world, women have constantly been denied equality in law and also in practice. They are compelled to live under the male-dominated world and are subjected to a variety of discriminations. Consequently, the UN have incorporated a series of treaties and conventions to achieve the equal legal and political rights of women worldwide. International Law on Violence Against Women. Convention on Elimination of Discrimination Against Women, specifically Article 1, states that for the purpose of the present convention, the term discrimination against women shall mean any distinction, exclusion, or restriction made on the basis of sex, which has the effect or purpose of impairing or nullifying the recognition, enjoyment, or exercise by women, irrespective their marital status, on a basis of equality of men and women, of human rights and fundamental freedoms in the political, economic, social, cultural, civics, or any other field. From these words, if interpreted logically, derive many aspects of violence. The words like distinction, restriction, nullifying the recognition, enjoyment, and exercise made a complete sketch of violence against women in the line of discrimination. The three parts definition of violence against women given in Article 2 of the Convention on Elimination of Discrimination Against Women, 1967, focuses on all the aspects of violence. Perhaps before concluding the definition, the UN has gone through many debates to make the issue and concern all around complete. The International Covenant on Economic, Social and Cultural Rights, 1966, specifically Article 3 states that the equal rights of women and men to enjoyment of economic, social and cultural rights. The International Covenant on Civil and Political Rights, 1966, states the equal rights of women and men to enjoyment of civil and political rights. The Declaration on the Elimination of Discrimination Against Women, 1967, spells that the discrimination against women is fundamentally unjust and constitute an offense against human dignity. Lastly, in 1993, the Declaration on Violence Against Women is a milestone for the countries for enacting their domestic laws on this subject. Laws relating to violence against women in India. Under the Indian law, the meaning and scope of violence against women could be clear from the criminal and civil laws which address the offense as to violence against women. Criminal law. In India, the criminal law is substantially based on the Indian Penal Code, 1860. Further, it is supplemented by the special laws and other Supreme Court guidelines. Indian Penal Code, IPC, 1860. There are certain provisions under the Indian Penal Code which deal with offense in the form of violence against women. Violence against women may be categorized as follows. Number 1, physical violence. Number 2, mental or psychological violence. Number 3, sexual violence. Number 4, physical and mental violence. Now we are going to discuss physical violence in detail. Offenses which amounts to physical violence are as follows. Number 1, dowry debt. Section 304B IPC deals with dowry debt. It is the worst kind of violence wherein many married women have been killed at their matrimonial home by her husband and relatives out of greed of dowry, causing hurt and grievous hurt. Section 319 and 320 IPC. It is a common form of violence. Section 319 IPC defines the expression hurt as causing bodily pain, injury, infirmity, and disease to any person. However, serious hurt is termed as grievous hurt under Section 320 IPC. Unlawful confinement. It is another form of violence. When the movement of the woman is restrained or confined within the four walls of the house, it amounts to violence, which is an offence punishable under Section 340 and 349 IPC. Procuration of minor girls. For the purpose of prostitution, the procuration of minor girls from one part of India to another part is an offence under Section 366A IPC. Importing girls below 21 years of age from outside India for the purpose of prostitution is an offence punishable under Section 366B IPC. Under Section 372 and 373 IPC, selling and buying minors for the purpose of prostitution are offences punishable under the aforesaid sections. Enticing or taking away or detaining with criminal intent a married woman is a criminal offence and the offender can be punished under Section 498 IPC. Death caused to the pregnant woman by act done with the intent to cause miscarriage is a culpable homicide punishable under Section 314 IPC. Now, we are going to discuss mental or psychological violence. Abetment to commit suicide. Section 306 IPC deals with abetment to commit suicide. Whoever by instigation or by conspiracy or by intentional aiding allows a person to commit an offence is abetment. Next is bigamy. Section 494 IPC. Marrying again during the lifetime of the husband or wife is bigamy. Essential ingredients of bigamy are: A. The accused was already married to some person. Number B. It was a valid marriage. Number C. The person whom she or he married was not dead. Number D. The accused has married again to another person during the subsistence of the first marriage. When a man commits the offence of bigamy, it amounts to mental violence to the first wife, and the person can be punished under this section. Next is adultery. Section 497 IPC deals with adultery. Under this section, a woman's husband is guilty of adultery if, number 1, he has sexual relationship with a woman who is married to another person. Number 2, he knows that she is married. Number 3, he has reason to believe that she is married. And number 4, he does not have the consent of the husband of that woman to have sexual relationship with her. If a married man leads an adulterous life, it amounts to violence to the lawfully married wife of that man. to insult the modesty of a woman. If any person intends to insult the modesty of any woman, utters any word, makes any sound or gesture, or exhibits any object, intending that such word or sound shall be heard, or such gesture or object shall be seen by such woman, or intrudes upon the privacy of such woman, is an offence punishable under Section 509 IPC. What are sexual violences will be discussed at this point. Sexual violence. Number 1 is rape. Section 375 IPC. Rape is the act of physically forcing women to have sexual intercourse that is forced upon. A man is said to commit rape who has sexual intercourse with a woman. Number A, against her will. Number B, without her consent. Number C, with her consent if consent is obtained by putting her or any person in whom she is interested in fear of death or of hurt. Number 2, she gives her consent under the misconception that the person to whom consent is offered by the woman is her lawfully married husband. Number 3, she is unsound of mind or under intoxication of substance administered by him or through some other person. Number 4, with or without her consent when the victim is under 16 years of age. It may be worthwhile to mention that while Section 375 IPC says about constructive rape, Section 376 2 A, B, C, D deals with custodial rape, and Section 376 2G deals with gang rape. Ordinarily, rape is violation with violence of the private person of a woman and outrage by all canons. Next is Section 377 IPC, unnatural offence. This section is intended to punish the offence of sodomy, perjury, and bestiality. The offence consists in a carnal knowledge committed against the order of nature by a person with a man, or in the same unnatural manner with a woman, or by a man or woman in any manner with an animal. Next is Section 493 IPC. It deals with the offence of cohabitation caused by a man deceitfully inducing a belief of lawful marriage. Next is physical and mental violence. Number 1, the causing of miscarriage and injuries to unborn children. Forceful termination of pregnancy amounts to violence to the women. Section 312 to 318 IPC deal with the commission of causing of miscarriage, of injuries to unborn children, of the exposure of the infant, and of the concealment of birth. Causing of miscarriage is not a penal offence if such miscarriage is caused in good faith for saving the life of the pregnant woman. Otherwise, the person who causes miscarriage is punishable under Section 312 IPC. The person who causes miscarriage or abortion without the consent of the woman can be punished under Section 313 IPC. In such case, the punishment is more severe. Kidnapping, abduction or inducing women with intention to compel her marriage. Section 366 IPC deals with the offence of kidnapping, abduction or inducing women with the intent to compel her marriage. Outraging the modesty of a woman. Assault or criminal force to women with intent to outrage her modesty is punishable under Section 354 IPC. Next is cruelty. Section 498A. Husband or relative of husband of a woman subjected her to cruelty. Whoever, being the husband or the relative of the husband of a woman, subjects such women to cruelty shall be punished with imprisonment for a term which may extend to 3 years and shall also be liable to fine. For the purpose of this section, cruelty means any willful conduct which is of such a nature as is likely to drive the woman to commit suicide or to cause grave injury or danger to life, limb or health, whether mental or physical, of that woman. Harassment of the women, where such harassment is with a view to coercing her or any person related to her to meet any unlawful demand for any property or valuable security, or is on account of failure by her of any person related to her to meet such demand. Special laws. Number 1, the Dowry Prohibition Act 1961. Number 2, the Commission of Sati Prevention Act 1987. Number 3, the Prenatal Diagnostic Technique, Regulation and Prevention of Misuse Act 1994. Number 4, the Immoral Traffic Prevention Act 1956. Conclusion. The aforesaid provisions of the Indian Penal Code and the special laws are the laws in force in India so as to curb the problem of violence against women, which is an obstacle in the advancement of women in order to bring legal equality set forth in the Universal Declaration of Human Rights. As India is a vast country with many diversity, each community has its own custom and outlook regarding the view, opinion and status of a woman, thereby violating legal equality of women and their fundamental freedom. Despite the legislations, violence still continues and the country has to go a long way in order to achieve legal and social equality in its true letter and spirit. Legislation cannot, by itself, solve the deeply rooted social evils and violence meted out to the fairer sex unless the view of the society is reformed. For eradicating the social evils like the dowry and the violence, effective steps can be taken by the society itself, and social sanction of the community can be more deterrent, yet legal sanctions in the form of its prohibition and punishment are some steps in that direction. Greater social awareness and more severe legislative measures are urgently required to curb the dowry-related deaths and other social evils. Thank you.